Thank you for participating in this webinar. My name is Frank Musica. For over 30 years, I have served as the professional liability consultant to the Documents Committee of the American Institute of Architects. Our company has had a person working with that committee for over 60 years. One of the task groups of the AIA committee has been working with various companies and organizations in the design and construction industry to update the AIA documents guiding digital practice. This summer, the AIA Contracts Document Program released its new set of 8 documents: exhibits that are added to design and construction contracts, a freestanding licensing agreement, a prototype BIM Execution Plan, and 2 forms of an Excel spreadsheet that can be used as model element tables. I will provide you with some basic information about the documents, but this is not meant to be an extensive examination of how they work, what they contain, or how they affect your internal practice management procedures. There is a lot to learn about the new digital practice documents, and the AIA Contract Documents program has many samples, articles, and webinars that explore the documents in more detail. Let's start with these learning objectives. I am hopeful that after this hour or so, you will have a basic understanding of how the digital practice documents provide you with the tools you need to take the next step in using digital information as part of your efforts to convey your design to those who have the responsibility to construct what you intend in your design documentation. I want to make sure that you learn about one of the more prominent changes in the new set of digital practice documents. And that is that for the first time, the documents recognize that there is an increasing and reasonable demand by project clients that some portion of the digital documents be included in a set of information provided to a construction contractor as a contractual obligation for the contractor. The E201 exhibit allows model versions to be part of the contract documents. And although we cannot go into the BIM Execution Plan prototype in detail, I want you to appreciate how a BIM Execution Plan, which the parties sharing the digital information commit to following, can define exactly what, when, and how information will be shared. I also will discuss the standard of care, and while using the digital information has been evolving over the last 2 decades, this new series of digital practice documents does not, by itself, change the standard of care for your professional services in any way that is unmanageable or unintended by your negotiated contract with your client. Okay, it was in late July that the new series of AIA Digital Practice Documents was released. And if you follow our blog, you already have read posts about the 8 components of the digital practice documents. Unlike the earlier BIM-related documents and forms, they both track closely with what is happening in the construction industry, and they significantly disrupt one of the existing conventions of design practice. The new series of documents and forms give architecture firms and others using digital documents an ability to increase the value of the design firm's digital data by making part of the data a contract document. But that also presents risks to firms unaware of the nuances of the data sharing environment. The use of models on construction projects is becoming so common that almost every project uses BIM in some way. And therefore, every project is subject to the risks associated with modeling. The risks are not new and certainly are not created by the new series of documents. Those of you who attended the AIA National Conference in Chicago this summer probably rode the shuttle buses past Soldiers Field, which was constructed or reconstructed 20 years ago and extensively used BIM. It had many problems in sharing the design information, including problems that created errors in the fabrication of the structural steel. But that was an early sharing of BIM information, and the safeguards in place in the new digital practice documents did not exist. The AIA Contract Documents program really faced the reality of modern construction. So while it both tried to enhance and streamline the sharing process, it also recognized that some BIM model versions will be used as contract documents. That is not new. Right now, civil engineers designing highways often provide digital information as contract documents. So using the AIA Digital Practice Documents means that the parties involved on the project, the architect, the owner, the contractor, and all the subcontractors and consultants, know how models will be shared, used, and relied upon through a contractual BIM exhibit. On some projects, the parties make decisions early in that design process about what digital design data will be included as part of the contract documents. Prior digital design documents ignored the fact that increasingly clients and contractors want at least some level of digital data of the design firm's BIM model as information on which the contractor can rely in the construction of the capital asset. The information-rich BIM models and data can now be added to the architect's contract deliverables and not just used for design. But of course, there are both risks as well as opportunities. So you need to understand what is to be shared while you are developing that information. And you need to charge for the services in preparing model elements or model versions for sharing. As an architect, your intellectual property, your BIM model, and every part of it has values that others can tap. So you need to be paid for that creating effort and paid for the sharing of your information. Okay, let's look at this. This is how the AIA Contract Documents program illustrates the use of exhibits and the separate sharing contract. This is from the free AIA Digital Documents Guide, which is available from the AIAcontracts.org website. We will look at the 5 documents, the E201, E202, the E401, E402, and the 3 listed below the schematic, and the C106, and the 3 listed below the schematic, which are the G203, G204, and G205. Just to interpret what that means, there are 2 major exhibits, the E201 and E202, which are mutually exclusive, but basically set up the agreement to share information. The difference that we will look at is that the E201, the one in dark blue here, is a document that makes some digital information into a contract document. The E202 does not. It's shared among the same parties, but it doesn't make any of the information rise to the level of a contract document. The E401 and E402 are what the AIA committee refers to as siloed sharing systems. The E401 shares information among the design team members, while the E402 shares the digital data within the construction team. The C106, the ones in the upper corners in the light blue, that's the licensing agreement. It's not much different from its earlier version. It was published in 2013, and probably does not differ significantly from what you might currently be using to share information for a fee and with massive restrictions with another entity involved in the design or construction. Those are documents that are aimed at sharing information outside of the normal contract basis of all the parties involved in the project. So that's when you can share information using the kind of fee and protections that many of you have in your own contracts. Okay, here's another chart from the AIA Digital Documents Guide. And this really shows the sequence and how the documents are used sequentially in a project. First, the stakeholders decide on what BIM exhibit to attach to their contracts. Remember, there are two major sharing exhibits, the E201 and E202, and two silo exhibits, the E401 and E402. After that high-level negotiation, that's negotiating a contract. These are attached to the contract. Then the senior level BIM coordinators decide what BIM execution plan to use, which could be a version of the AIA's G203 that we'll discuss later, or some other BIM execution plan. For instance, if you have ever provided services to Penn State University, you worked under its well-crafted BIM execution plan. And then step 3, the BIM experts develop a model element table. Again, that could be the extensive G204, the abbreviated G205, or some other model element table that the parties create. Now, we'll talk about the E201 2022 edition. It is not an agreement, and it currently does not stand alone. It must be included as an exhibit to existing agreements for design services or construction. E201 is intended to be used in situations where the project participants agree that a model version, some element of a model, may be enumerated as a contract document. There is no requirement to deliver an entire model. The participants can define specific systems or assemblies to deliver as data assets for analysis or fabrication, or even the creation of a digital twin for the project owner. AIA document E201 establishes the parties' expectations regarding both the development and the use of digital data, including whatever elements of the building information model are shared. Having set the baseline regarding digital data and BIM expectations, E201 then requires the project participants to develop and to adhere to a specific BIM execution plan, such as the G203 that we're talking about. There are level of development definitions in E201. Each level of development is defined in Article 4 of E201, and also in E202 for that matter, and communicates both the minimum amount of data required to reach the defined LOD and the maximum extent to which the model element at such a level of development can be relied on for the defined and authorized uses. Okay? We'll look at this article in more detail later in the program. The LOD definitions are used in the model element tables to establish how each model element will be developed as the project progresses. And as I said, this is not only in E201, it's also true with E202. Like E201, E202 is not an agreement. It will not stand alone. It must be included as an exhibit to the existing agreements for design services or construction. Both E201 and E202 are intended to be used where all the project participants will be sharing model information. The difference between the two documents is that E201 permits model versions to be enumerated as contract documents, as part of the contract documents, and E202 does not. Right? With both E201 and E202, the protocols established as a result apply to all the parties, such as downstream subcontractors and even sub-subcontractors. They require the parties to incorporate the exhibit, E201 or E202, by reference into any other agreements for services or construction for the project. Therefore, the Contractor is obligated to incorporate the exhibit into subcontracts, and the subcontractor is obligated to incorporate it into the subcontract. Similarly, the architect is required to incorporate the exhibit into its agreements with its consultants on a project. So all downstream sub-consultants and sub-consultants will have E201 or E202 incorporated into their agreement, and by its terms, agree to follow the digital data and BIM protocols established and set forth in the BIM Execution Plan, such as that in the AIA model document of G203. As I said earlier, E401 and E402 are intended to be used when models will not be shared among all the project participants. The difference between these two documents is the focus of the sharing. E401 allows sharing among the entire design team, which is defined as the architect, its consultants, sub-consultants, and sub-consultants at any tier. So E401 anticipates a more siloed approach to modeling, where the design team creates and distributes models within the design team only. And those models are not intended to be shared with the owner or with any member of the construction team. The A402 allows sharing between the entire construction team. So it parallels with the E401, right? The information is not to be shared with all project participants. Neither E401 or E402 allows that. But the E402 allows sharing within the entire construction team. So again, the construction team is defined as the contractors, subcontractors of any tiers, and the fabricators. Here's a basic layout that is part of all the exhibits. These sections are common, right? They talk about model uses, sharing, and reliance. They talk about the need for the BIM execution plan to be put in place. They define the levels of development. They look at what non-BIM digital data could be provided. They talk about all the details of ownership and sharing and security of the digital data to protect all the parties who are sharing that information. Note under 7 is a short provision that addresses the insurance for BIM and digital data risks. It only states, in addition to those insurance requirements set forth in the agreement, the governing agreements to which this is attached, all project participants developing or using models or digital data shall purchase and maintain the following insurance coverages. And then it allows specific coverages to be listed. For the most part, this is meant to require firms to have appropriate cyber liability coverages in place. Remember that your professional liability insurance covers your liability in the performance of professional services. Your failure to meet the standard of care for professional services that causes costs, losses, or damages to another party. With creating, sharing, and controlling access to digital information, there are many exposures that are not related to your negligent creation of the information you share or your negligent use of the information shared with you. The exhibits require the participants to check off the uses of the model information. There are 6 enumerated uses: planning, design, construction management, construction, and post-construction. And one that allows stakeholders to be creative in what the model will be used for. So, it tries to specify and gives examples of what each of these categories really talks about. Okay, model sharing. There are various sharing tiers, and this comes out of E201. If you look at that's the exhibit that allows digital information to be used as contract documents. That's authorized in 2.3.3 or Tier 3, right? It's prescriptive sharing with all project participants enumerated as a contract document. So that's specific to E201. The other exhibits would only have Tier 1 and Tier 2 levels because that information cannot be used as a contract document. And both Tier 1 and Tier 2 have specific and restrictive language in the definitions. Although the AIA contract documents program has a model BIM execution plan, the stakeholders, of course, can use their own plans, develop their own. They may already have plans in place. The client may very well have what it considers the proper BIM execution plan that it wants the contractor and the design team to use. So stakeholders can use their own plans, but the exhibits all require a minimum of these 9 details to be included in whatever BIM execution plan is used. Now, some of these are the highly technical software and data protection requirements. Some of them are management issues, and others are focused on the legal authorization of use and on the level of reliance on the shared information. So these are mandatory items that need to be in any BIM execution plan, whether it's the AIA version or something developed by the parties or something the project owner has as its BIM execution plan. Now, all the exhibits include an Article 4. We pointed that out earlier. And that Article 4 is on levels of development. These are basically the ones that were created over the years by the BIM forum that the AIA was part of, but that other associations and industry groups are part of, and develop standard levels of development definitions. Section 4.1 in the exhibits is the level development descriptions. The LOD descriptions are used in the BIM execution plan to identify the minimum required characteristics for each model element at progressively developed levels. Other project participants may only rely on a model element consistent with the minimum required characteristics for that designated level development. Now, let me correct one bit of information. Some firms seem to use LOD to be short for level of detail. That is not the case, since some BIM information that has not been developed extensively actually might include a high level of detail. Others that have been developed may not have the same extensive level of detail. So it's not a detail issue, it's a level of development. The reliance is not on the detail, but rather the state of the information's development. If you have been actively using BIM, you know that this highlighted area, level development 350, did not used to exist. It does now because the industry as a whole basically created it and has adopted it. There's also a provision on non-graphic information. Non-graphic information may be attached to a model element. If non-graphic information has a different degree of reliance than the model element to which it's attached, then the model author is required to indicate the difference in the model element table or elsewhere in the BIM execution plan. And that's because it's one thing to rely on the shared digital information, the graphic information, but if there's other information that goes along with it, that has to be looked at separately. That has to be authorized by the model author for a specific use. And while safeguards are in place for the model information, the exhibit also states that for the creation, the storage, the management, the archiving, the sharing of digital data other than the models, the participants will use their own protocols, except in what they may have negotiated or noted in their BIM executions. Confusing if you're new to using BIM, certainly for those of you who have been using BIM, that's probably to be expected. Okay, now with G203 that was released this summer is a prototype BIM execution plan. It's really a framework that can be used to create a project-specific BIM execution plan. It contains multiple fill points and is really intended to actually stimulate conversations among the project participants and document their decisions on how they will utilize BIM on the project. All the BIM exhibits contain language requiring the parties to adhere to the BIM execution plan. So even though it is not a contract document, it is not an exhibit by itself, the exhibits that the parties agree to tie it in and say that you must adhere to the BIM execution plan once it's developed. They're contractually obligated to adhere to its terms. So again, it's not intended to be a contract exhibit, but whatever exhibit is used requires the parties to follow. Once a model becomes a deliverable that can be relied on or may be enumerated as a contract document, it is critical that there be a way to identify it so the user knows what it is. The BIM exhibits set forth reliance provisions for models and model elements that vary depending upon whether the model version in question is a designated milestone deliverable or an interim deliverable. And if the model version has been identified or labeled as a designated deliverable, then the project participants may rely on the model elements as set forth in this G203 or other BIM execution plan. If a model version has been identified or labeled as an interim deliverable, basically for information on an interim basis, it then becomes the duty of the model author to indicate really the extent to which which the model author is really authorizing reliance on that version, that interim version. It may just be, here's what's going on and it's for information purposes, and it's not something you can order equipment to meet right now. In either case, the model author has to identify or label what their model version is at the time it is being issued. And in the case of an interim deliverable, to further specify the reliance provisions that they're permitting related to how it can be used. Now, there's some concerns that this could get out of hand, that there might be too much information flowing back and forth, and that there may be increased risk because of that. I think the documents are well thought out to try to prevent that from happening. But again, the parties are legally obligated to follow the BIM execution plan. If they follow it, I think many of those risks do not occur. Now let's talk about G204. That's an example, a prototype of a model element table. One of the biggest changes to the AIA Digital Documents family tool is the addition of this and the G05, the 205 model element table. The G204 and the G205 are two independent model element tables, which are suited to two different levels of BIM implementation and sophistication or familiarity. Both model element tables are now offered as Excel documents. If you were working with the 2013 versions, examples, they were Word tables, so they were difficult to use. The Excel documents is something that the industry really called for. Remember that the G204, the model element table, is not an agreement. Rather, it's a project form used to document the LOD decisions once the project participants have agreed on it. Because the protocols are set forth in the form and not as part of the agreement, they can be modified in a different way. You don't basically have a change order to make a modification. So it's easier for project participants to revise the protocols as needed to evolve with the project's needs. For some smaller projects, it may seem intimidating to fill out the G204 because of the specificity required by the CSI uniformat. That has 4 levels of detail, so it gets into really specifics. The AI realized that they needed to have a simpler version of that. So the G205 is an abbreviated model table. It only goes to level 3 rather than level 4, and that cuts out a lot of information. But as with the 204, the G205 abbreviated model table is not an agreement. It's a project form used to document LOD decisions once the project participants have agreed on it. And it really guides on what that information is going to be used for. Now, I mentioned that the C106 that has been around for a while. It was updated this time around. It's the 2022 version is similar to the 2013 version with some minor modifications. The C106 really serves as a licensing agreement between two parties who otherwise have no existing licensing agreement for the use and transmission of digital data, including instruments of service. So, if people are signing contracts, they're part of the chain, the contractual chain, and they have certain rights to use that information. If you're outside of that chain of contractual agreements, then you need something else, and you need a licensing agreement, and that's what the C106 does. It really defines digital data as information, communications, drawings, or designs created or stored for a specific project in digital form. It allows the creating party, the one party, to grant another party a limited and non-exclusive license to use some of the digital data on a specific project. It also allows them to set forth procedures for transmitting the digital data, and it really does place restrictions on the license granted. In addition, and I think very importantly, the language of C106 allows the party transmitting the digital data to collect a licensing fee for the recipient's use of the digital. And any of you who have digital sharing agreements of your own probably have followed the information either published earlier by the AIA or in our contract guides and our negotiation language on our website about how to handle getting paid for sharing information with a party who otherwise would have no right to that information, and how to protect yourself from misuse of that information. Now, again, parties that have previously executed AI agreements for design services or for construction, those parties have already entered into licensing agreements pursuant to the provisions of their agreements, the A201 or the B101 and the subcontractor agreement. To establish the protocols for the transmission of digital data, including BIM information, or restrict the usage rights permitted in those agreements. Parties use the building information modeling exhibits such as E201 or E202 and incorporate it by reference into their pre-existing agreements. Right? So that sets up those relationships. But in this case, you don't have those relationships, so you come up with a different licensing agreement. And the circumstances mentioned in the last bullet item include situations where the receiving party is compelled by a lawful court order or other compulsory legal process to disclose the confidential digital data. Otherwise, it does remain confidential. So that last bullet item refers to the permission of the disclosure to others on the project, so they may perform their work or services as long as they are subject to the same disclosure restrictions set forth in the C106. Now let's talk about some concerns you have, because I know firms have a lot of concerns. These, I think, are the basic concerns that many firms have expressed to us. Is my information protected from misuse, from reuse, from alteration, from appropriation by other parties? Now that BIM is used as it can be part of the contract documents, is that a greater risk for me? Will this system, the BIM sharing, actually make me provide more information without getting paid to do so? What about my professional liability insurance coverage? And basically, do I have a choice, or is this the way the industry is going? And so let's talk about your concerns with the changing world around you and the AIA contract documents program response to those changes. First, if you use these documents, your contribution is protected legally from misuse. Of course, the law and contract language might not discourage improper use, but that has always been the case. That no matter what language you have in, no matter what agreements you have, even in the licensing agreement, someone may violate the terms and misuse the information. But I don't think you can obtain better protection than the protection built into these sharing agreements and procedures. And if you know that certain model versions and model elements are going to be relied on by the contractor as part of the contractually required contract documents, you have the ability upfront to control your risk by what you provide. Yes, design firms do not want certain things to be contract documents. For years, contractors have said make shop drawings contract documents, but design firms do not want shop drawings to be able to be relied on by a contractor as part of the owner's warranty of the adequacy of the information. But as we have seen with engineers, providing digital data as part of contract documents does not by itself create any greater exposure. As a creator, you have to understand the value of your creation to others, and that value means getting paid for it. As a negotiator up front, you have the right to strike the right balance for you between compensation and the service you're providing. So do get into a situation where you're getting paid and not a situation where you are giving away for free information that you created. Use the increased sharing as a way to capture the increased value of your documents. As long as you are part of the system, as long as you're creating that digital data or that BIM model, and you're sharing elements of that BIM model with others, make sure you're getting paid for that, because it saves other people a lot of money. Contractors are using BIM far more extensively than I think many design firms are. The design firms may be using it for design purposes, but contractors want to use it for a lot more. Whether it's pricing out a project, whether it's scheduling a project, contractors have, I think, really progressed in what they're doing, and they're relying on digital information far more than in the past. In fact, we saw this starting to happen after the 2008 recession. Many contractors who saw this as their future started hiring away from engineering firms and architecture firms people with BIM knowledge and bringing them on board into the construction industry, so that contractors can get more out of the models they create and the models information that's shared with them. Now, from the professional liability standpoint, there's never been an issue in the CNA program with digital information being used in the creation of the capital asset. BIM really is a tool, perhaps more sophisticated than your old T-square and pencil, but it's still a tool that allows you to create and share information. You have coverage for your negligently performed professional services. But remember that your professional liability insurance is not a policy that covers everything you own or operate. So you need to look at other insurance coverages that cover many of the high-tech parts of what you're doing, your equipment, and whether that's cyber liability, because obviously if there's a ransomware attack that keeps this BIM information from being properly transferred or corrupts the information, that's not a professional liability exposure, that's a cyber liability exposure. And if you plan on creating value and staying relevant in the creation of capital assets for clients, you don't have a choice. And using these digital practice documents to advance your practice and enhance your value makes a lot of sense. Now, I mentioned to you that the AIA has put out a lot of information. The contract documents program provides tools, it gives away contract samples, it has various commentaries, and what's pictured here, which is the digital documents guide. That is free to download from the AIAcontracts.org website. You search for BIM under documents, and you can search under the Learn tab for articles and other things on that. And this digital documents guide alone is something that every firm should have, even if they're not specifically using the AIA version of digital documents. They need to understand how they're set up so that they can understand how to protect themselves as they're sharing information. The AIA also has its own YouTube channel. The AIA Contract Documents program has its own YouTube channel. And it has webinars, and it will have more webinars on the digital documents in the future. So please go to those resources and tap those resources through the AIA website and through YouTube. Now, with that, I'm really going to end it. I want you to make sure that you access our information. If you go to our school risk management website, you will see news and events on the right. That's where you probably registered for this webinar. That's also where you can link into the blog if you haven't done that directly. and learn more about things like these, the three-part blog posts on the digital practice documents. There are other tools and resources on our website, and I encourage you to go to that and look for those tools and resources, because we will be putting more information out on digital practice as we go along. With that, I will look to see if we have any real questions that I can answer this way. You know, if you have a question and it relates to your professional liability exposure or coverage, please feel free to send it in, and we will try to answer your questions directly. Okay, and with that, I think it's probably time to stop. I thank you for your participation, and you know, I hope you will be signing up for our upcoming webinars, which are include something that most firms know very little about, the ESG, environmental, social, and governance requirements that's being placed by investors on many companies, and how that affects you. And we'll be talking about other programs later in this year. So please go to that website and you can see what's coming up. Again, access the website. Do not forget that we also frequently write in our blog about emerging risks and opportunities. So subscribe to the blog. Now look for the survey and provide us with your comments. And with this slide, I thank you for listening, and I will conclude today's webinar and hope you will sign up for